What exactly did Luigi Mangione plead guilty to? Why now? And what does this federal plea mean for the upcoming New York State trial? Just some of the questions you've been asking since Luigi Mangione admitted in court to shooting healthcare CEO Brian Thompson. I'm Jordan Dunbar, and I'm going to be trying to get you some answers today in this episode of the Mangione Trial podcast from the BBC World Service. To get those answers, I'm joined by two top legal experts. We have Gary Galperin, a former assistant district attorney in New York County and now professor of law at Cardozo Law School, New York City. Hi, Gary.
Hi, Jordan. How are you?
I'm very well. Thank you for joining me. And also with us is Todd Spodek, a defense attorney in New York from Spodek Law Group. Hi, Todd.
Hi, how are you?
Very well. You're both joining me from New York today. Gary, I want to start with you. Simple one. What exactly did Luigi Mangione plead guilty to?
He has two cases, a federal case and a state case. His guilty plea was on the federal case, and he pleaded to 2 counts of stalking in the federal case, what they call stalking using interstate commerce and stalking using interstate facilities, basically traveling across state lines using the internet, cell phones, and the like to track and ultimately kill Brian Thompson. So the thrust of it is stalking.
And Todd, why do you think the defense decided to do this now?
So certainly this was a strategic decision since the death penalty counts were already dismissed. They put themselves in a much better position to resolve the federal case, hopefully with a favorable sentence, and avoid a New York State trial altogether.
Okay, well, I just want to go back to that day in court because we haven't actually heard from Luigi Mangione in this case. We've had a few outbursts at hearings in the past. But at that federal hearing, he made a statement. The court appearance wasn't recorded, so we've had this voiced up by one of our team.
After years of enduring severe pain from a broken back, navigating the obstacles of the health insurance system, and witnessing similar experiences of countless others, I learned that United Healthcare would be holding its annual investor conference in New York City on December 4th, 2024, although the specific location was not publicly disclosed. I then researched the event online. I observed that the annual conference of America's largest healthcare organization, with the slated mission to make health system work better for everyone, would be attended by company executives, the board of directors, and hundreds of investors, not doctors, nurses, and patients. In November of 2024, I traveled from outside of New York State to Manhattan. I then emailed United Healthcare leadership posing as an investor at a firm managing over $50 billion in assets and requesting information about the conference. Unlike my previous interactions with insurers, I received an immediate response within an hour. Before traveling to New York, I used a 3D printer to make part of a gun, and I equipped the gun with the silencer and magazine. My travel to New York and email to United Healthcare was with the intent to shoot Brian Thompson. On the morning of December 4th, 2024, I shot Mr. Thompson in Manhattan, and he died. When I did so, I understood that my actions would place him in fear of death or serious bodily injury. I knew what I was doing was illegal.
Gary, the statement that Mangione read in court and the detail in it came as a surprise to many. In the UK, for instance, you would just say guilty or not guilty in one of these hearings. But Mangione, he actually had to give certain details for this plea to be accepted, didn't he?
Yes, it is the custom practice law in American courts, especially when you're pleading guilty to a serious charge, a felony charge, that beyond saying the word guilty, you need to show that there is a factual basis for the guilty plea. So the judge will turn to the defendant and ask him to describe what he did factually so that the record supports factually, legally, that there is enough reason to believe that he is in fact guilty. So he did come with a prepared statement.
Todd, you mentioned there you thought that this is part of a defense strategy, and that's the reason why they did it now. But I'm wondering why the defense decided to let Mangione or encourage him to go into detail in that statement about, having a broken back, hearing of others who've experienced obstacles when navigating the health insurance system. Why would they do that?
So Luigi Mangione and his defense team are trying to build a narrative for the federal sentencing hearing that's going to ultimately come up. The judge has essentially unfettered discretion as to what the appropriate sentence should be. And so they're trying to provide as much mitigating evidence to support his actions, why he did this, the motivation, what he was experiencing. And I would anticipate that there will be a forensic psychologist or some sort of medical professional to explain what happened to Luigi Mangione's psychology throughout his ordeal with the health insurance system that led him to commit this horrific act.
Is it rare to get statements like this where you've got a motive and in many ways a kind of a personal message too?
So in the Southern District of New York, the judges do require that the defendants actually allocute themselves, whereas other federal districts, the defense lawyer can either do it or the defendant can just affirmatively say yes to a resuscitation of the facts. But in the Southern District, the judges require the defendants actually speak in their own words as to what they did. The additional information regarding his medical history and his motivation is not relevant to the plea allocution, which was what Gary was referencing, but certainly is mitigation for the future sentencing hearing. Why this offense is an anomaly, why it's unique, and why he should ultimately be spared from a life sentence.
Okay, that's interesting. So that statement was all about speaking basically to the judge while they wait for sentencing in that
Correct.
federal plea. We did get a sense of the strategy behind the kind of the plea that the defense were going for. In the statement given by Mangione's defense team immediately after this plea hearing, Karen Agnifilo said that she was filing the paperwork for a motion to dismiss the state charges, so that's the state trial, due to New York's double jeopardy clause, which has caused lots of people online to be Googling and asking about double jeopardy. Gary, can you explain the double jeopardy clause and why it's different in New York?
Yes. So when the public at large hears about double jeopardy, they think of it in very simple terms. You cannot be prosecuted twice or convicted twice for the same crime. And that's generally true. But under New York's criminal procedure law, there are a number of additional provisions expanding on that basic guarantee. So in fact, one can be potentially prosecuted based on the same criminal activity, which is clearly what we have here. No one has ever disputed that we have one criminal transaction, ultimately the planning of and the execution of shooting Brian Thompson. So same criminal behavior, same criminal transaction. Under New York state law, you can prosecute based on that if the two jurisdictions in this case charged Mangione with different offenses which have different elements from one another. And I think the parties in the Mangione case, the state and the defense, are certainly in agreement that there are different elements. You have the stalking elements and you have the murder and weapons elements on the state side. But that's not enough. In addition to the different elements of the offenses, they have to be designed to prevent very different kinds of evil. So the analysis, the judge's determination will come down to that very specific question. Did the federal charges or are the federal crimes designed to prevent a very different kind of evil than the charges that he's still facing on the state side?
So I'm just going to remind the audience here. So Mangioni's pleaded guilty to 2 counts of stalking resulting in death at the federal court. But at the state case, the charges are 1 count of second-degree murder, 1 count
That's
of
right.
criminal possession of a forged instrument, which relates to the fake driver's license, 6 counts of criminal possession of a weapon. Todd, if you're Mangioni's defense, are you confident in your motion over double jeopardy?
I think they have a very strong case to bar the prosecution in New York. New York's laws are incredibly broad when it comes to double jeopardy. And ultimately, it is the same transaction here. And I think that they have a very strong case to ultimately prevail.
Gary, the language of the federal charges, he didn't plead guilty to murder. This was stalking resulting in death. So is that different enough from, second degree murder?
The federal and state charges culminated in the same ultimate act, the killing of Brian Thompson. What's interesting about the federal charges is that the stalking statute is about following someone, surveilling someone, intending to injure, harass, intimidate someone across state lines, and with the intent to cause that individual's death. You actually don't get to causing death until you look at the penalty provision that was also pleaded in the indictment. So I agree with Todd that the defense definitely has a good argument, a good faith argument to seek a double jeopardy dismissal of the state case. But I think the prosecutor has very good arguments to oppose it and to ultimately prevail.
So you're less confident than Todd is that the defense will prevail. You think the prosecution also has a good chance of arguing this?
I do, and clearly I'm informed by my experience as a longtime prosecutor, and also just having studied the statutes. The federal stalking statute came about in, I think, 1996, really focused on giving law enforcement additional tools to deal with victims of domestic violence or other types of criminality across state lines. So they were really looking at female victims. They were looking at celebrities who are stalked. So it really came about, and this is what we're talking about, the legislative intent for specific purposes, which I think the state prosecutor can say are very different than New York's murder statute.
And you've dealt, as your time as a prosecutor, you've dealt with double jeopardy cases before, haven't you?
I have. It doesn't come up very often, but I had an organized crime case here in New York City, for example, where the capo of a particular organized crime crew was charged with different crimes in New York State, and he also had a previous federal conviction for similar type of activity, and he made a double jeopardy claim, which he ultimately did not win. And Paul Manafort, your viewers and listeners may know, the former campaign manager for Donald Trump, former associate of Trump, was prosecuted both federally and by my office on the state side. And he actually prevailed in his double jeopardy claim, where the judge at the trial level and then the appellate court agreed that it was all about his fraudulent activity, both federally and on the state side, and therefore it would be double jeopardy to prosecute twice.
Todd, whatever Judge Caro decides on the 10th of December, this is in the state trial, there will be appeals back and forth, won't there? This won't be a quick decision.
Absolutely. The defense has every intention of bringing this to the highest court possible to litigate double jeopardy, and they will. Ultimately, it would go from the trial level state court to the Court of Appeals. And that would be the appellate division that would decide this ultimately. That would be the end result.
So this strategy is essentially by pleading guilty to these federal charges, you'll get a sentence on that, but there'll be no trial. And then hopefully the defense think, right, this will set off the double jeopardy clause, so we get rid of the state trial as well. But that argument's still happening. Hypothetically, if it wasn't found to be double jeopardy, the appeal got thrown out and we did get to a state trial, I'm trying to get my head around how that would actually work. If you're the defense and you do have to go to state trial, is it about arguing down the charges? So rather than not being guilty of everything, it's about trying to get the murder in the second degree charge, for instance, reduced. How would it actually work if they did get to that state trial?
Ultimately, if they wound up going to trial in that case, what I think a lot of people don't understand is the issue is factual guilt and legal guilt, right? The prosecution has to prove the elements of a crime beyond a reasonable doubt. So from a defense point of view, you could factually be guilty of this crime, but the question is whether the prosecution can prove those legal elements. So they'd want to attack the elements of each crime. And yes, obviously they'd want to attack the charge that carries the highest penalty, which is life, first and foremost, because if they could knock that out, it's guaranteed release ultimately from prison, which is, in my point of view, the same strategy with this whole double jeopardy thing. On the federal side, there's no parole. So if he does not get life and he just gets some sentence, there is a chance of one day walking free. Whereas on the state side, if he was to go down, he could theoretically be held indefinitely.
Gary, I'm wondering from the prosecution's point of view, the whole way through this, we've heard, especially on the state side, for New York, this murder caused serious panic in, not just the business community, but, New York's reputation around the world, and that the state prosecution wanted to make an example of Mangione, that you cannot do this. What do you think their end goal is? Like, do you think they would accept a plea around this case, or they really want to go to trial?
They definitely would accept a plea if he's willing to plead to murder in the second degree, the top count in the state indictment. What Mangione has done is really boxed himself in, because if the case is ready to go to trial, he's lost his double jeopardy motion, he's lost his appeal, then his admission of guilt in the federal case is actually usable as evidence now in the state trial. So he had a very tough case to begin with. But now add to that he has admitted his guilt quite completely, there would be really very little that he could argue at trial realistically. So it would be a conviction equal to a trial verdict if he pleads guilty to the state case. This is not a plea bargain. There's not going to be any real negotiation here. He can plead guilty, and then each side will make their pitch as to what sentence he should get, especially in light of the federal conviction. And then Judge Caro will make his determination.
Todd, if it did go to a state trial, do you think the defense have any chance of convincing one member of a jury or, several members of a jury that he is not completely guilty of the different charges?
So I'd have to agree here that there's no real viable defense strategy here, right? I think there is potentially this idea of jury nullification. So I agree. I think this is going to end up with either it being resolved on appeal and ultimately, they'll bar the state prosecution, or if that doesn't work out, there will be a guilty plea to wrap that up as well.
Could you just expand on what jury nullification is?
So jury nullification is not a valid legal defense. It's not like the defense team can argue that he committed this crime, but he should not be found guilty because the health insurance industry is corrupt and he felt justified in doing this. That would not be permitted under New York law. However, certainly you could drop hints of things throughout a trial with the hope that the jury on their own decide that even if he did commit this crime, they're not going to convict him. It's not a legal defense, but in reality, you never know what a jury does, and they go to deliberate and no one's there but the jury, and they could determine guilt or innocence based on anything that they want. So it is common for defense lawyers to sprinkle things that they want them to consider.
Gary, when we spoke before, you had talked about a hung jury and how it would just take one juror to have a different opinion and that would change everything.
Yes, so I agree with Todd. However, it only takes one juror to essentially nullify or to want to vote not guilty despite evidence of guilt beyond a reasonable doubt. And if one or more jurors are of that mind, there would be a hung jury because we need all 12 jurors under American law, certainly under New York state law, to be unanimous in their verdict. So if there's a hung jury, that's not the end of the case. And in such a serious case as this, there is no doubt that the New York County DA's office would plan on retrying him.
But at some point, would it stop and they would just have to make some sort of deal?
So yes, there could come a point where after multiple trials, let's say, both sides reassess their positions and try to come to an agreement short of yet another trial. But given the seriousness of this case, that's not going to come about too early in the process.
Gary, one of your specialisms is around psychiatric evidence, and there was a point during the summer where a defense was put in EED, extreme emotional disturbance. It was put in by the defense and then it was taken away. It was withdrawn quite quickly. That means that it can't be used if the trial happened, the state trial. Does it also mean it can't be used in sentencing hearings?
Having withdrawn his psychiatric notice, the extreme emotional disturbance defense, he would not be able, if the case went to trial, to present psychiatric evidence of that defense. However, much in the way he spoke of his history of back pain and all that went with that in his federal guilty plea allocution, in the state sentencing hearing, he can certainly talk about what was going on in his life at the time of the killing, in the period leading up to the killing, in the hopes of getting some mitigation on the state sentence. So if the case goes to trial, it's off the table. But at the sentencing, he is free to make a very complete statement about his motivations.
So he wouldn't be calling experts or anything like that, then it would just be him talking about it?
It would be very unusual for there to be expert testimony taken after a guilty plea to be taken at the state sentencing. But as part of pre-sentence submissions, the defense can do a memorandum. They can include affidavits from doctors or from anyone who might have relevant information. So the defense would be able to get, if they so choose, mental health information before the sentencing judge.
I think it'll be helpful if I just touch on one thing that just came up, just that the viewers may not fully understand. One thing is raising the emotional distress as a defense to the crime, which is no longer an option. But as mitigation, it is an option. So there's a distinction. So when the defense withdrew that was as a trial defense, but they still preserve the right as mitigation in the federal case or in a future state case.
So that would be December 18th. At that sentencing, that's when they'd be able to use that.
Correct.
Well, just sticking on December 18th thing, it sounds like this is actually going to be quite an important hearing because Luigi Mangione can make a statement about his mitigating circumstances, but I believe the Thompson family can also talk about like victim impact and what this has caused them.
Yes. So the federal sentencing is open, meaning it's not the usual scenario where you agree to a sentence and a judge just sort of signs off on it. The judge has to make an independent determination as to what the appropriate guidelines are and what the appropriate sentence is, and take into consideration a number of different factors. So at that sentencing hearing will be perhaps testimony and arguments about all of these issues, about Luigi's life, his childhood, his adolescence, his education, mental health struggles with the health industry, and all the things that were going on with him, and what led him to this unfortunate sequence of events. But on the flip side will certainly be the family of the decedent, who's going to talk at length about how this has changed their life forever. And, all of that is information that is ripe for a judge to consider at sentencing. So that will be a key date, and certainly the most important date of the whole case. And then they either will make a determination right then and there, or it's sometimes common for them to take a brief recess to consider everything and come back maybe 30 minutes later or something. But I would 100% anticipate a decision on that day.
Todd, do you think the defense's strategy now is essentially trying to get sentences that mean Luigi Mangione will get out of prison with years to live? Is that what success looks like?
Yes, 100%. From my point of view as a defense lawyer, it's twofold, right? So first and foremost, yes, you're dangling the prospect of one day leaving prison and being able to, potentially live on the outside again. And two, not only has this case garnered immense press attention, but he has a family, he has people connected to him. And at some point, you also want to close this chapter for everyone involved. So I think it's a balancing of both of those things. But certainly paramount is the idea that one day he'll be able to walk out of prison.
So I just want to sum up what we've talked about here and the different options that could happen. So number one, the state case gets dismissed on double jeopardy grounds. Number two, the state trial goes ahead, and we've discussed what that could look like. But Gary, is there a third option? So Judge Caro decides not to dismiss the motion for double jeopardy, but Mangione could then just plead guilty in the New York state trial, right?
Yes. So if the double jeopardy motion is denied, two things could happen. The state trial can go forward, or Mangione can decide to plead guilty. And I think if he loses the double jeopardy motion, he has no path to victory if the state case goes forward. So I think it would be a foregone conclusion that he will plead guilty to the state charges.
Well, Gary, I'm interested in, what do you think the prosecution is looking for in terms of whether it be sentence? They put out a statement saying they were committed to getting justice for Brian Thompson's family. For them, is it about length of sentence? What would they be looking, for them, what does success look like at this point?
The state definitely would want and does want to obtain a conviction on its own case, even though it's the same fact pattern and everything we discussed before. When it comes to sentencing, I strongly suspect that if he is convicted either by a jury verdict or by guilty plea of murder in the second degree, that the district attorney will be recommending the maximum of 25 years to life. He can and will become eligible for parole at some point in the distant future. So it's not a sentence that New York has in other cases, such as murder in the first degree, where it's life without parole.
Okay.
So he would become eligible at some point.
Well, we're talking about December 18th. That's federal sentencing. How will it work if he does get a sentence through the state trial? Do they get added on with each other? Are they concurrent, consecutive?
So assuming that Judge Caro would be the second sentencing authority, it would be up to him to decide whether or not the prison term that is imposed on the state case runs concurrently with the federal prison term or consecutively. That would be his call and his prerogative under the law.
Well, we will find out more on December 10th in the state trial and that sentencing hearing on December 18th for the federal charges. Gary Galperin and Todd Spodek, thank you so much for joining me today.
Thank you for having us.
Yeah, thank you.
And thank you for watching and listening to the Mangione Trial Podcast. If you'd like to find the rest of our episodes, you can get them by subscribing to the BBC World Service YouTube channel or wherever you get your BBC audio podcasts. See you next time.